Mic is on.
Good morning, ladies and gentlemen. Now, this is a brief presentation on what I have coined this phrase, whatever, integrated land information for the country. Now, as we are aware that every nation mostly, but we have a very well laid down constitution. And in our constitution, there are three lists: the union list, the state list, and the concurrent list. In subjects which are given under the union list, only the parliament can legislate. In subjects under the state list, only the states can legislate. And in the concurrent list, both the states as also the union can legislate. And in case there is a conflict, the union legislation prevails. Now, there are two entries in our state list, entry 18 and entry 45. From this, it flows that land is a state subject. So the power to enact laws relating to land rests in the legislatures of the states and not in the parliament. So a logical corollary and a natural corollary to this is that every state has its own state-specific revenue laws to deal with land and its administration. Here we use the word revenue in India also to mean land administration. Certain provisions are also given in the constitution itself, so that neither the parliament nor the states, they cannot tinker with them because they originate and derive their existence from the constitution itself. But these provisions are mostly related to northeastern states which have certain special features, and also to the National Capital Territory of Delhi. Then there is another subject which is registration of documents. That is a concurrent subject. It means that both parliament as also the state governments, state legislatures, they can legislate. So in case there is a union legislation, the states can come up with state-specific amendments, but yes, they would require the assent of the union government, that is the president. When we talk of land administration in India, every authority which deals with land has to do in the field at the grassroots level in the states. They have to perform certain administrative functions, and also they perform certain judicial, quasi-judicial functions. And the whole subject cuts across land laws, land tenures, land revenue, that is collection of the rent, land reforms, and land records. Before going further on this subject, when we speak of record and survey operations, I would just like to explain that we have essentially three types of records in the rural areas. One is the record of rights. There they write down something, that is a textual record. Then we have a field book that gives the surface details. The record of rights gives the rights of the individuals over the land and to the extent to which they can exercise those rights. The field book gives the surface details, whether the land is irrigated, it is not irrigated, etc. And then we have those cadastral maps. They tell us the longitude and the latitude where exactly the plot of land lies. So we call it record operations when we revise the record of rights and the field book. That is when we revise the textual records. And when we add cadastral map to it also, it becomes a survey operation. But whether we are revising only the textual data or we are also revising the digital maps, it has to be conducted as per the due procedure and law, which is prescribed in the state-specific revenue law, which is relevant to the subject. The registration of documents is taken under an old act of ours, that is the Registration Act of 1908. Now, this is only the registration of a document. It is not registration of a title or bestowing of a title. That is a confusion which generally obtains amongst people, even in our country and even experts from outside, because they go by the dictionary meaning of the word registration. That is not so. It is just pure and simple registration of a document. We have two sections in the Act. One is Section 17, one is 18. Section 17 provides that such and such document, if it is not registered, it shall not have any evidentiary value. And Section 18 says that any other document, they also give an illustrative list, not a comprehensive list, but they also say any other document. So any other document, in case you get it registered, it adds to its evidentiary value. So to create evidentiary value, without that, the document will not have any evidentiary value. We have those documents which are listed in Section 17. And in case somebody wants to add to something and make it more authentic, that document, he can take recourse to Section 18. Registration per se does not confer rights or ownership or title, and neither does it create a presumption or assumption of rights or ownership or title. Now, this initially, a myth was obtaining in our country that if you get a document registered, it is giving you some sort of rights. But to finish off this thing, we are trying to now, it's in the final stages, we are taking it to the cabinet and then to the parliament. We are bringing in an amendment in the Registration Act in which upfront we are going to record exactly this phrase which I have used here, that the public at large becomes totally aware that no right per se flows from registration of a document. After you have registered a document, then you go in for a process of mutation with the concerned authorities, and that document is used as evidence. Then when we talk of mutations, mutations are quasi-judicial proceedings. By the very nature of a quasi-judicial proceeding, it will essentially have to have three elements. One is publication or a notice. Let the people know that this thing is going to happen, so that if anybody wants to object, he can object. Then you have to afford an opportunity of hearing and of adducing evidence. And then you have to pass a reasoned order. And that reasoned order would be subject to higher judicial scrutiny also. So mutation cannot be automatic following registration. The due process has to be followed. And there is a distinction between automatic and automation. You can always computerize things. You can make the processes faster. You can have flow of information. But that particular aspect of giving a notice, hearing the other side, and passing a reasoned order has to be done. And that cannot be automated. And it cannot be just that you have registered a document and it gets mutated. That is not possible. But what is feasible and what is desirable is that whatever registration of land takes place, that information immediately goes from the sub-registrar's office to the revenue office. Then the publication and the notice is immediate. And then as soon as the quasi-judicial proceedings are over, that order of mutation is immediately put into the land record database. Now, transfer of land in rural areas in the country, transfer, sale, inheritance, gift, mortgage, is being duly done with the existing land of record of rights, read with the cadastral map. Because these two things, what is the record and where does that piece of land lie on the Mother Earth, that's the basic thing. And these two, I would say, documents, let me say, they also derive their existence under state laws, that they have a statutory backing. Transfer by sale, that is registered, covers a very limited gamut. Most of it is by succession. And in certain states, that succession, in case it is undisputed, as an administrative exercise, the revenue authorities in the field, they enter the name of the next person, and that fellow does not have to go in for a quasi-judicial mutation proceeding. So mutation cases are only filed if there is a sale, if there is a disputed succession, or if the undisputed succession is not entered in the routine in the field by the revenue authorities. Then they go to the court and say, you kindly enter it, and then the court so directs. And the succession under our revenue laws is different from that under civil laws. So the Hindu Succession Act or this thing does not apply to devolution of land, which is done under the respective state laws. And most of them are heavily loaded in favor of, keeping in view the socio-economic milieu, they are heavily loaded in favor of the male lineage. Land administration is a very difficult subject in our country. It has a very wide canvas. And a sound administration is very important because the very way of life and livelihood of more or less every person in our nation is connected with land. So it is not only per se important, but it also provides a strong fundamental and a strong foundation for maintenance of law and order, and also for promoting and facilitating development and welfare works. So if we talk of law and order, or say criminal administration in the field, development administration and revenue administration, I would say that the revenue administration is the backbone of administration in the field, and the other two, law and order also is dependent on a strong revenue administration, and development administration also is dependent on a strong revenue administration. In this context, updated and error-free land records and easy access to information thereto are fundamental requirements, and particularly when we see that there's a large incidence of land-related disputes in our country, so error-free records and easy access to those records becomes very important. Now, if we talk of our nation, the overall position of land in the rural areas, which come under Part 9 of the Constitution, Panchayats, and the urban areas, which is 9A, municipalities, is materially distinct and distinctively different from each other. There are some overlaps, but we cannot talk of land in our country without making a basic elementary primary distinction between urban areas and rural areas. In general, in the rural areas, those northeastern states and certain constitutional provisions apart, the system of the fundamental three records, the record of rights, which in Uttar Pradesh we call the Khatani, that's the local language, field book, which in Uttar Pradesh we call Khasra, and the cadastral map, which in UP we call Shijra, is fairly widespread of. And the essential record of the landholder's rights are the record of rights and the cadastral map. And generally on the basis of this, they are in peaceful possession and enjoyment of their lands as per their rights textually recorded in the record of rights and spatially depicted in the cadastral maps. So this is indirectly that academic, philosophical, with due regards, non-practical approach of having conclusive titling or registration of title or title by registration. This is an antithesis to this, what I am saying at this moment here. And I do not, as an administrator also, and also as the secretary of the department, I do not agree with that recommendation that we should go in for a regime of conclusive titling, especially in the rural areas when people are peacefully enjoying their land, and for all intents and purposes, they can sell it, they can transfer it, they can mortgage it, they can gift it with the existing records. The case is made out to make the existing records better. In urban areas, the records are maintained by the revenue authorities as far as the land is concerned, by the development authorities, those authorities like the daily development authorities, which takes land and develops it and makes it available to the people, the municipal authorities who provide the municipal services and also charge some property tax. And there are certain other authorities also from place to place. So there are a plethora of authorities which maintain property and land records in urban areas. As far as the municipal record is concerned, that is only for the limited purpose of property tax. It does not per se confer any title or right. But yes, it becomes evidence in a title suit which is decided in a civil court. In the rural areas, generally the revenue courts function. These matters don't go to the civil court. After the revenue courts, they go generally straight to the High Court. The immediate need in the rural areas is to provide, I'm emphasizing each and every word, online, single window, at a glance, access to all available, relevant information to give a fair, comprehensive position of any plot of land to the landowner, concerned officers and agencies, and interested persons, entrepreneurs, etc. And this will not have the shortcomings and negativities of a de novo quasi-judicial or judicial exercise of registration through a new agency for land titling. Again, this is pun intended towards conclusive titling. I don't advocate that. In urban areas, certain improvements are definitely required and necessary as far as maintenance of land records and information thereto is concerned. And simultaneously, in urban areas, we have fairly more widespread problems of unauthorized or illegal occupation or construction, unauthorized or illegal encroachment over government or public or other persons' land, and civil and revenue litigation. So we have to keep this thing in mind when we think of something in the urban areas. But again, the immediate need in urban areas is to computerize and integrate the land and property records as presently available with the development authorities, the municipal authorities, the revenue authorities, and all the other authorities dealing with land and property records in any particular urban area. And a concurrent step would be to link and integrate this database with the position of encumbrances with banks and financial institutions and the position of litigation. In fact, Mr. Klaus here is also integrally associated with the ease of doing business of registration of property, in which they are working in two cities of Delhi and Bombay. This principle has now been adopted at the highest level in our government, that in these two cities we should immediately do exactly what this slide is showing, because that is the real essence of what all those parameters which we have taken to ease the business are concerned. This is the basic essence, that in case we are able to achieve this, about 80% of what we want to do through those parameters would be achieved. So this is the crux of ease of doing business, what we have now decided for Bombay and for Delhi, and we have already started work, and these things are minuted, documented, and also action has started. But what is relevant and doable in the immediate future is development of an integrated land information system for the rural areas that is related to my department, and computerization and integration of land and property records, and linking them with encumbrances, and linking the position of civil and revenue litigation for urban areas across the country, not only limited to Delhi and to Bombay under the ease of doing business parameters, but in all urban municipal areas across the country. But this is the charter of some other ministry, not my department. So now from this slide onwards, I'll be only concentrating on what our department is doing. We had a program of modernization of land records, started in 2008. Then, to give emphasis to this program, earlier it was a centrally sponsored scheme. There was a sharing pattern between the union and the states. Now we have made it into a central scheme. 100% assistance is by the union. That is the importance which we are giving to this program. Now, the present endeavors under this program are to build upon the commonalities that exist in the various states to develop a sort of fundamental structure of an integrated land information management system on which the different states can also add state-specific needs as they may deem relevant and appropriate. Because every state has its own state-specific revenue laws, own needs. So we are giving a sort of basic structure on which they can also add, but that commonality and that basic structure would be there. So we had collected all the states together last year. I had presented this concept to them. Most of the states, they had, in fact, all of them, they had agreed to it. And now we are one in this, though the subject is with the states. but all the states and the union, we are going together towards putting on the ground an integrated land information management system for rural areas, on which the states can obviously add to the resources and to the ingredients. Now, we have certain existing components of the program. In effect, they translate into cogent activities. That is computerization of the record of rights, digitization of the cadastral map. The field book we are not touching, and it is not required to be touched also because it changes from year to year and it only gives the surface details. And it has nothing to do with rights, etc. Then integration of the textual and the spatial data. Then survey and resurvey, again survey the whole land and create the record afresh, and that has to be as per the due process. Modern record rooms, data centers at the tehsil, subdivision, district and state level, connectivity between the revenue offices, computerization of registration as a parallel stream, connectivity between sub-registrar offices and tehsils so that the information of registration of land can flow from the sub-registrar to the tehsil and immediately the process of mutation can be triggered off, and integration of registration and land records. We took certain policy decisions. One decision which we have taken is that we will not unnecessarily carry out survey and resurvey operations. Because if you start a survey or resurvey operation, as they say that best is the enemy of the good, but this is not best also. It will take 5 to 10 years. There will be litigation. Every man will have to have an interface with the state. And in case the records are fairly normal, don't go, and people are in peaceful enjoyment of their land as per the normal records. Go ahead, digitize them, computerize them, integrate them, create a system, and that perfection which you want to do can be a concurrent stream, but that cannot be a condition precedent to doing these things. So unnecessary surveys and resurveys we would not like to have. This is a subjective evaluation. And this was not liked by the survey companies, etc., but that's not our problem. Then we also clarified that there was some confusion going on in the field that wherever it's a municipal area, the record should not be computerized and digitized. We said whatever whatever record is available with the revenue authorities, even if it is falling in urban areas, that has to be computerized and digitized. Yes, in urban areas, there would be other authorities also dealing with land and property. Let them keep their own record. But our record, if it is being maintained, it should be maintained in both rural areas and urban areas, so that confusion which was obtaining in the field has been removed and now everybody is doing it. Now, certain additions which we are wanting to do now in our program is to depict the information of revenue court cases so that the position of litigation is readily discernible on the land record database. Then we also have a system of circle rate in our country. That is the rate at which a sale, for the sale in case you have to give stamp duty, that is the minimum rate on which it is calculated so that people don't evade stamp duty. So whatever is the circle rate, that should also be depicted. So that is one valuation of land. That is not the only valuation of land. But one standardized valuation of land would be available on the land record database. Then we also have a social security number type of thing now, in Aadhaar. But we have a large number of court cases and judicial pronouncements. So adhering to those pronouncements, also integrated with that. And as a next step, to also link it with the encumbrances with the banks. Banks are already computerized now. And in case this system also comes in, so we just need one software in between to act as a translator so that the two softwares can talk to each other. So, but then that flow of information off the land to the banks and from the banks to the land record database would become very fast. We have started doing it in one union territory. I'll come to that subsequently. But this is also envisaged for the country as a whole as a next step. The first 3 steps we have already started. So This sort of a system will improve the real-time information on land, optimize use of land resources, reduce the disputes, benefit everybody, and not have any of the negativities attached with the conclusive titling regime. So this is a pictorial depiction of what we envisage to do. The things in green, I think, they are the components which we are already doing. The one in red, we have started doing, and the one in blue, we envisage to do. So the sub-registrar would be connected with the tehsil, that is the land, and the tehsil would be connected with the bank. Information would flow both ways. I'm sorry, I'll get back to it. So far, we have started this program in 457 of the 683 odd districts that are reflected on our central MIS portal. Implementation is very tough. Gestation period for these many of these activities is fairly cumbersome and this thing. But now, substantial progress has been achieved in the basic fundamental requirements of computerization of land records, record of rights, computerization of registration, connectivity between sub-registrar offices and tehsils, and integration of registration and land records. Computerization of record of rights is completed in 15 states, ongoing in 16, and not reported on the central MIS portal by 5 of the states. Out of them, 1 of them has done it, but they have done it from state resources, so we are taking it up with them that you kindly start reflecting it, so they'll start reflecting it. But as on now, I have given the information which is being reflected on the central MIS portal. This is the position. The states in red they just not started. And in purple is 100%. This would be available subsequently, but it also shows that the large part of the country, it's more or less now going on quite well. And that is just the computerization of the textual record. I'm sorry, I'm not a left-hander. And computerization of sub-registrar offices, again, it has happened in 17 states, 12 it's ongoing. 7 have not started, but we'll be able to start it very fast. There's wide disparity cutting across the country. Connectivity between sub-registrar offices and tehsils, it has been completed in 95 in 11 states, and completion we take to be when it is 95% plus, because 100% saturation would never arise. It is land is a dynamic sort of thing, and wherever 95% plus comes in for RORs and for digitization of cadastral maps, we take it. Here, completed 95% and above, we have met because the states keep on creating more tehsils and sub-registrar offices. So we say that more or less, if it is 95% and above, it's okay. Now, integration of registration and land records is meaningful only and only if the RORs are computerized, the maps are digitized, they are integrated, registration is computerized, and connectivity between these things is there. So when we were talking of these fundamentals earlier, we saw that there is wide disparity in the performance in these fundamentals. So unless and until all of them are perfectly done simultaneously, there would be no integration. So some of them are lagging behind, some of them are going fast. We have to now pull up the others also and start working together so that simultaneously the whole thing is put into place. We took up a project in Chandigarh as a demonstration project. where we computerize the record of rights and digitize the cadastral maps in both rural and urban areas. We integrated them. We established connectivity between the revenue offices and the registration offices. We integrated the process of registration with land records. Then publication and notice for mutation is now automatically generated on receipt of information of registration. We have integrated Aadhaar also. We are also now more or less reaching the culmination of putting information of circle rate and revenue court cases litigation in the land record database. And more or less now the information is being updated on a real-time basis. So we presented this project to all the states, and also there was general consensus that this can act as one demonstrative replicable model in other states, obviously mutatis mutandis to the extent applicable, with suitable technical, administrative, legal, etc. changes as are appropriate and relevant in the concerned states. State of Uttar Pradesh has computerized all its records, made them available on their Bhulek portal. Revenue court cases have been computerized. The status of court cases can be viewed online. And a 16-digit code has been given for each and every parcel of land. And the first 6 digits, they represent the village code, and we have adopted the same code as is adopted for census purposes by the RGI. And the next 4 digits, they give the plot number, then the division status of the plot, and the last 2 digits represent the category of the land use. This is useful for administrative purposes, for preventing benami or fraudulent transactions, and also identifying suitable land for development purposes. And in India, we have a system of starting our measurement from fixed points, which we call border pillars. So to each and every border pillar also in Uttar Pradesh, we have given a similar 16-digit unique code. So the codification of the plots and the border pillars is unique in Uttar Pradesh, which we have already put on the ground, and that is our largest state. And this can also now be adopted by the other states, and we are trying to now get the other states to adopt them also, and the union is playing a facilitating role. And this was something which was done outside the purview of the union's DLRMP program by the state through its own resources. As far as registration is concerned, when we were computerizing registration, we found that the software being used by the different union territories and the different states was specific to the concerned state. So we created a national generic document registration system with our NIC, and we are now motivating the states to move to this common generic software so that sitting in one place, we can see the position of registration across the country. So we started it about a year and a half back. We field tested it. And now 3 pilot states of Rajasthan, Punjab, and Maharashtra, they have already moved on to this software. And 3 more states of Bihar, Manipur, and Madhya Pradesh have also moved in. And about 7 of them are also in the process of moving. So we are hopeful that by 30th June, the first week of or July or whatever, most of the states would have adopted this thing and started moving to this common software. The advantages would be that we would have countrywide uniformity in computerized registration and anywhere access to data and information. So this is going to complement our integrated land information management system when simultaneously the computerization of the registration of documents is going on, but then the software also becomes one and the same across the country, so that anybody sitting in Delhi can see what is happening in Bigulsarai or in Bhagalpur or in Bhind, Morena, Punjab, and also reports can be generated for the authorities also. Now, the issue which is important now for both these streams, the land information system and also the common generic software for registration, the issue which is important is that the fundamental framework which we are providing through this union, and in addition to that, the state-specific needs which are being added by the states. We need some technical assistance for the states, some authority or some agency to provide that sort of assistance, and also to evolve some commonality in the systems and the processes being adopted by the different states, whichever is the best one, they adopt it. Then dissemination of state-specific good practices from one state to the other. As, for example, Uttar Pradesh, they have codified their plots and their pillars, and that can be adopted by the other states also. Then effecting uniformity in the contents and softwares amongst the states. And most importantly, that the quality, accuracy, and relevance of these two things, the integrated land information management system for rural areas, I'm talking only as the secretary in charge of rural areas, and national generic document registration system for both rural and urban areas. We are doing this thing in our urban areas also. The quality, accuracy, and the relevance gets some acceptability. Here I had a discussion, and I also made a request to Mr. Klaus that perhaps the bank can see whether they can look into this aspect of quality, accuracy, and relevance. Because on the one hand, we get a validation of our efforts, and on the other hand, they get something to do. What do you say, Klaus? But I'll be grateful if you can look into it. And one suggestion, just going by this is the last slide, going by the title of this thing, Land Governance in an Interconnected World. What I personally feel and very strongly feel, that whatever is the constitutional and legal position of land records and land laws, in every country should be succinctly articulated and placed in the public domain, like we are trying to do for rural areas in our country. Anybody sitting in Mozambique can see what is happening in the United States and vice versa. These are the land laws. And at a glance, single window access to land and all information which is relevant to the land should be available across the globe. And this has to happen sometime or the other in the future. If it does not happen now, it will happen after 20 years. Perhaps we'll see it from the astral world. But this is the need of the hour. For our nation, it's a difficult task. We have already started it. The suggestion to my esteemed good friend is that he could also take this thing, that why don't you start doing it uniformly across the globe. Thank you very much. And in case anything extra is required by any person, one is the Deputy Secretary, the other is the Joint Secretary. They are both knowledgeable officers. These are their emails. And obviously, I can also be of assistance. Thank you very much.
Okay, thank you. So before going into the general discussion, let me just make a couple of comments on this extremely rich presentation. And then I think we can discuss whether we have enough to do or we can do some more. I think what I find very striking is that India's experience really is highly relevant to many of the topics that have been discussed during this conference. I think, as the Secretary has clearly laid out, land administration and securing property is a basic function of the state. And I think it's something that deserves the highest attention. But at the same time, high accuracy doesn't equate legal security. And a lot of misunderstandings and mistakes have been made, and a lot of money has been wasted on that. That mutation is a quasi-judicial process. And I think we had some discussions on the blockchain where I think this is something that is very much relevant because the social consensus and the agreement that you have in the process of affecting mutation is something that I think blockchain people are still struggling with, and is a very open discussion. Also, I think something that wasn't mentioned, but I think is very important in the context of India, is that property has a social function. And so it's not only about individual rights, but it's also that land administration needs to benefit the poor and the common man, because unless we do that, I think the potential for development will not really achieved. That publicity is a key element of land administration, and I think Secretary Singh put it very well in terms of the quality, the accuracy, and the relevance. And I think India clearly illustrates, and there I have been personally learning a lot about the huge benefits that can be achieved by integrating the system, and the enormous progress that has been made under the guidance of able individuals in India. I think India's experience is also quite relevant in telling us that countries or states neglect the importance of land records at their peril. And unfortunately, that is something that has happened in too many states in India, where the esteem in which revenue administration has been held in the past, I think, has been eroded quite rapidly. And of course, especially for rural land records, some of the rationale for a program like the DILRMP is exactly that neglect of this important function. But of course, also, I think the failure to maintain property cards for urban land. And what does that mean? It, as was illustrated in the presentation, it leads to dispute and litigation, which then clog up the court. It creates law and order problems. It limits the development of financial markets, and it undermines the basic for planning and basic functions of public administration. Also, I think what is very clear, if you look at India, which has a population much greater than Africa, is that records need to fit the local realities. And we should not go for the illusion of one-size-fits-all approach, whether that is conclusive titling or anything else, because I think records evolve in response to local needs, and the local needs in the northeast of India, where you have essentially customary tenure systems, are quite different from those in downtown Mumbai. So I think you need to standardize from the bottom up and understand the realities to which land administration is responding. And I think that is exactly the approach that has been taken. But of course, at the same time, improving land records is a key public responsibility, and the development of an integrated information system for rural areas, as well as computerization of all of the urban records that are available, is important. And I think integration with Aadhaar, with court cases, with banks, and with tax and planning records is something that has huge potential, and I think that can decide about the competitiveness of countries, and where I think the reference to the doing business is very much appropriate. Of course, as was outlined in the presentation, there are essentially two elements of the record quality. One is the textual one, and India has made quite a lot of progress in terms of computerization of the ROR, the computerization of mutation, and the integration of Aadhaar. As well as the spatial component, where I think, and I'll show you some figures too, where maps need to be, I think the sequence is essentially that maps need to be of good quality and digitized. Then georeferenced, there needs to be a linkage to the ROR. And that linkage can either be one time, or it can be automatic updating, which I think is what the DILRMP aims to achieve. And of course, then there are all the linkages that really add value to that. So let me just show you, if we look at the data that have been presented in graphical form in a little bit more detail, it's very clear that there is considerable progress with essentially 86% of ROR having been computerized, 46% having computerized mutation. Digital signature of ROR is a little bit less, and I think the link between ROR and Aadhaar is still quite limited. I think essentially it's AP and Telangana that have achieved that. But of course, I think one of the things that is really amazing is that the MIS database of the Ministry of the Department of Land Resources, it contains essentially data that allow you to drill down to the village level. So we have here information about 656,000 villages. And so I think that really allows us to give a very, very good indication of how these are actually evolving, and also allows us to use this information for programming purposes. In terms of the quality of graphical records, I think if you look at the first highlighted figure here, 90.7% of villages in the country have good map sheets. So there is no need to go for expensive resurvey, because digitizing these, and I mean, you may create more trouble by going in and trying to redo all of these through an expensive survey operation that will not only cost money, but also raise a lot of issues about discrepancies in the historical record, which are still the legal basis, and something that is being done by a new modern survey. I think if you go through georeferencing and linking with ROR, as well as online linking and updating, the percentages become lower. And I think something that is very important is that through the use of a standardized software, which is Bunaksha in this case, you can actually make a lot of progress and incentivize the states to move on this very quickly. So if we look at that and we take these elements together, we see that the different states have made quite a bit of progress, but of course, essentially what you would want to see is people in the top quadrant on the right, and our states there, whereas you see a lot of, some of them, I think MP is the most outstanding case, has done a lot because they did a lot of survey operations in terms of improving the graphical records. Others, such as AP and Telangana, have done a lot in terms of improving the textual records and linking them. But of course, this is there's still some work to be done. And of course, we are not looking here in this graph at the elements that Secretary Singh outlined in terms of linking to banks, linking to court cases. But clearly having something like this available and having this updated on a regular basis will be the key for a constructive policy dialogue with the states, to show and to also create some competition. And that's where I think it's very, very important to go beyond the focus of doing business on two cities and really recognize the wide diversity in conditions and the potential for development that Indian states have. Also, I think I don't want, for time reasons, to go into that. But so clearly, I think there are two very important areas where we see potential for collaboration. One is on the registration. And I think that is really, we are very much in agreement that registration is the key to unlocking India's real estate wealth. There is enormous potential for improvement, and I think up to now, and I think there even the Doing Business project, I think, has been tinkering at the margins rather than dealing with the real issues, because what we need to do is really to link to a parcel ID and link to a personal ID so that you know where the specific piece of real estate is located and who owns it. And I think the potential for really moving on this very, very fast is tremendous. And so I think this is a very, very exciting area, and that, of course, that can help not only to reduce litigation, but also to foster mortgage markets. And then, of course, by guiding the states in a way similar to what was done under the DRMP, to actually have a bottom-up standardization, I think that can really then also facilitate cross-state transactions and harmonize things with enormous benefit. Second, I think it can be a lever for improving land use planning, and especially in urban areas, which I think is one of the biggest challenges that is facing Indian cities. And of course, once you can link records with the actual location, I think you can link and you can use spatial data and satellite imagery you can link that to municipal records, which I think is very easy then. And so I think you can really move towards to being actually an example in what the topic of our conference is, to have land governance in an interconnected world rather than in individual silos. And of course, I think the third element, which is really also very important and of great interest, is that it raises very challenging questions. One of them, whether a transfer tax regime that was introduced by colonial authorities because transfer taxes was the only way of raising revenue, is still suitable for the 21st century, or whether you should actually, and of course, which drives a lot of people into informality and is a key source of corruption and fraud and under-declaration of values, and you have it. Second, how to balance private and public roles in the provision of land administration, who owns the data, and of course whether to use blockchain or not, and how to use that if you want to go for that. But of course, in the rural areas, which I think is a little bit closer to home, I think it's also very important, as I've shown you, to establish and routinely report index of record quality that identify the data sources, design reporting software, publicize the underlying data, and really use them for advocacy and for pushing states to do better. And there, I think the model that we of doing business, taking one or two steps further to ensure granularity and actionability, is actually quite important. And of course, we had during this conference important discussions about the Sustainable Development Goals. And if we do that in the proper way, we can actually take a lot of significant steps forwards to include India into the reporting on social development goals, and cover also the social aspects, which I think will be at the global level absolutely essential if we want to achieve the target of moving to Tier 1 in 2020. Again, helping to share experience and lessons across states is, you have seen the diversity across the states. Every time I was lucky enough to be able to visit a state in India, there's been so much I've been learning from the examples and from the approaches that have been taken. But I think there's way too little emphasis on actually sharing this experience and documenting it in a rigorous way, and also evaluating it very carefully, because given the diversity that there is, I think there's a lot of potential for lesson learning, and also building state-level capacity for policy dialogue, which I think is very important if we want to move forward on that. So to conclude, I think clearly there's huge potentials to learn and share experience within India. Also, I think India is a microcosm of land administration issues, and these issues are of global relevance. And even if in a conference like this one here, we would ignore India's experience, I think it would be very much to our peril. So with that, I think we are very glad to have the Secretary here to share his wisdom and experience. And we hope that we can continue to collaborate actively on these issues and take that forward, which will also benefit us tremendously. Thank you. So with that, I think the floor is open for questions, discussion. Please, here 2. And Tim, 3, please. Go ahead.
I would like to congratulate Mr. Dinesh Singh on his very elaborate presentation and a mammoth task that his ministry is doing in digitizing the land records. 2 questions which I have. One is that you said in your presentation that you're not redoing the survey of land parcels. But in India, land is measured in a very different way across different states. Like, for example, in UP, Bigha, Bihar, Bigha, West Bengal, Bigha, all these Bighas are different. Rajasthan, Bigha is different. And in some states, it's Gunta, other places, it's Kila, Marlas. In what way are these land areas being registered in the record? Are they in their local ways, or they are into square meter? But if there is no survey being done, a fresh survey being done, how are they being reconciled with each other? That's my first question. And the second question is about some years ago, there was another mission, which was land titling, which was being done. And you are saying, as I understood, that titling is not being linked in a way, or title guarantee is not being linked with the land records. Or is there something which I'm missing here?
You see, in respect of the, am I audible? You see, as far as the survey is concerned, in fact, as far as digitization of the maps and also computerization of the record of rights is concerned, we have to clearly understand that land is a dynamic commodity. It will keep on changing. It is not a static sort of thing that the position of ownership on land will be static. It will always be dynamic. The plots, they will keep on being divided, especially with succession and also by sale. Where the records are more or less like the normal. You see, the policy circular which we issued, I would like to read it out again. I have quoted from there only in the slide, and I am now emphasizing every word. To ordinarily carry out survey or resurvey, ordinarily carry out. Only where the record of rights or the field book are not available. If they are not available, you have no choice. If the records have been destroyed, there is some flood, the village has been, wiped out, the fresh survey is required, or it is 40-year, 50-year-old survey. Obviously, we have to do surveys there. But if the survey is as per the normal, then it is not required to the detriment of other critical elements of the program. Only where the record of rights are not available or have been destroyed, damaged, outdated, etc. They become very old. And not to have unnecessary surveys when the land records are available as per the normal. What was happening was that in about, I think, 2013 districts, the work had started in 111 districts, so 213 minus 111, 223. 223 minus 111, odd districts, it had not started. So where the work had started, our decision was that in case it has started, you finish it off now. You can't leave it in between. But for the rest of the districts where it had been sanctioned, have a relook whether the records are as per the normal or are you just doing it for the sake of doing it. And most of these districts, the records, it is turning out, are as per the normal. And where they were actually required, the surveys had not been sanctioned till then. So it's a very, very carefully considered decision, and we feel that it's the correct decision. And in so far as conclusive titling is concerned, the two types of systems which obtain in the world as on date. One is what was done by the Surveyor General of Australia when he started conclusive titling in Australia. We called it the Torrens system. That was title by registration. That there was absolutely no record available, so they said you go come across, get your title registered, and you will get title by registration. The others are something which is being done in England, Scotland, and Wales. Is registration of title. It initially started something like the yellow pages. Okay, you have a title. You want to show to the world that it's unencumbered, it's perfect. Come and it's optional for you. You please come and get it registered. So it was registration of title. And gradually they started making it mandatory. Now most of it has become mandatory. Now all these things, they require quasi-judicial proceedings. They require money. They require a fee. So we don't think that we need it for the rural areas in India as of now.
I also have two questions for you, Mr. Dinesh. I'm working on compulsory acquisition of land in 3 countries, including India, certainly. And my question is in the context of the latest Land Acquisition Act of 2013 in India. It firstly says that it allows compulsory acquisition for private projects conditioned to the consent of affected landowners, whereas most of the developed countries are going away from acquisition or compulsory acquisition for private projects, and India is going towards it, or rather legally accepting it in 2013. Do you view this as an acknowledgement of market failure due to lack of availability of undisputed and clear conclusive titles? So this is the first question.
Second one.
Second one is about the compensation which is offered, and we know that it approximately sums to 4 times of registered market value in the rural context. And do you view that as a legal acknowledgement of undervaluation of land in the registered documents?
Insofar as land acquisition is concerned, it's outside the subject of land records, but I'll answer it. It's relevant, it's related to it also to some extent. Land acquisition again falls in the concurrent list. So earlier there was the Land Acquisition Act. Now it is the Act of 2013. The Land Acquisition Act was a union enactment. It's been replaced by the Act of 2013, about which you are speaking of. Mm-hmm. But prior to the Act of 2013 and subsequently also, there are n number of state-specific enactments under which, for different purposes, the states acquire land. Like, for example, we have an act for Uttar Pradesh for industrial development. If we acquire land, we acquire it under the UP Industrial Development Act. We do not acquire it under this Act of 2013. So one thing which I am highlighting is that there is a plethora of other acts also under which land is acquired. It is not the Act of 2013 alone. Second is that being in the concurrent list, every state has its own legislature, and in case they want to come up with state-specific amendments, they are welcome to do so. And already from 2013 till 2018, certain state-specific amendments have already come into the statute books, and this process has also started. And the third is that, yes, if land is required for development purposes, for infrastructure projects, it has to be acquired. And that you can only buy it and you cannot have forceful acquisition. That is not possible in the context of the situation in which obtains in our nation. But one has to be fair. There has to be an adequate compensation. The need has to be very, very genuine. The rehabilitation and the package has also to be simultaneously. All these things are being taken care of by the Act of 2013. Now, saying that in the rural areas it is 4 times, it is something like this. You see, it is market value plus it is 10% solatium, that makes it 2 times. And then there is a multiplying factor given in the first schedule that in case the land is situated in the rural areas, you can multiply this thing with a factor between 1 and 2, keeping in view the proximity to the urban area. It's a fair proposition because the value of land in urban areas is higher, the value of land in rural areas is lesser. And in case there is proximity, to because of urbanization, that thing would be moving towards that area. So to be fair to the farmer and to be fair to the landowner, then that becomes 4 times. Otherwise, in urban area, it remains, that multiplying factor is 1 then. Compensation package is there. It's a fair package. Minimal land acquisition has to be done. If it is done under this act, the provisions of this act have to be followed. If it is done under some other union enactment also, the NHAI, those linear projects, NHAI and rails, they do it under their acts. But the compensation package under this act has been made applicable on those acts also by an order which the government issued. So it's a complicated subject, but I personally feel that it's doing pretty good now, and it's fair.
Thank you.
Hi, Tim Hanstead from Landesa. Thank you, Secretary Singh, for the very comprehensive and I think informational presentation, and also Klaus for your comments, which I appreciated. I'm particularly happy to hear you say that you are not aiming to go quickly to registration of title or conclusive titling. I think that's wise, knowing what I know of India, both because it kind of follows don't let the perfect be the enemy of the good, but also because actually going there quickly has substantial risks, and that outweigh the benefits. So happy to hear about that. I wanted to ask a question about, also like the focus on quality, accuracy, and relevance that you had earlier. And I think on one of the slides, I think it was number 26, you mentioned that having integrated land management information system is meaningful only if, and you listed several bullets there, which I think are very important. So my question is about one bullet that I might have put on this slide in addition, and that is a bullet of it's meaningful only if the textual records in the record of rights are actually reflect substantially what are recognized as rights, socially legitimate rights on the ground. Because it comes to the issue of updating records of rights before either before or in the process of digitizing them. And the reason I mention this is because, and also it actually goes to one of your slides, Klaus, because on your graph of showing the different states, which ones are doing well on both the accuracy of textual and spatial records, you have Telangana and Andhra, but Telangana I'll highlight specifically as quite high on the textual side. And so our kind of pilots and gathering information, looking on the ground at the gap between the textual records and what is at least socially recognized on the ground as being the real records, shows that while in some states that gap is not very large, in other states it is quite large. And actually, one of those states where it's quite large is Telangana, which would seem to highlight the need for some type of process, and probably a community-led process, to try to close that gap, which, and I point it not so much as a problem as an opportunity to, as part of the land, improving the land records, is to help close that gap, which if you can do it as part of that process could be enormously helpful, particularly to more marginalized populations, because where we see that gap, the gap is largely kind of discriminating, I would say, or potentially discriminating against the more marginalized populations. So, sorry, that was a long wind up to the question. The question being, do you agree with me that it's important to try to look at that gap and maybe include processes that would try to close that gap while you're improving land records?
You see, first of all, thank you very much that you agree that there are certain risks involved with the regime of conclusive titling, perhaps which will outweigh the benefits. But, and in fact, one reason why I have not readily agreed to this land titling business is that I am aware of what passes through what a small and marginal farmer passes through. And putting him into a protracted interface with the state for 4 or 5 years that we are going to give you a conclusive title, when for all intents and purposes he can sell it, he can mortgage it, he can gift it, he can do what he feels like based on the existing record of rights. I would not like that to happen. They have a difficult life as it is. As far as your first observation was that the record of rights should actually depict the actual rights which are that person is holding. That thing is quite true. You see, there are a large number of items given in the record of rights, including right of easement, the extent to which the right is there. In Uttar Pradesh, the state from which I come from, there were basically 3 types of rights. One was with transferable rights. Second was without transferable rights, but with succession rights. Third was lease over government land or over community land. The record of rights are fairly good. The real problem is that our maps are not up to the mark in certain areas. That is one. And secondly, the digitization process of the maps is very slow. And it's a common sense that why it has happened, because that's a more complex and more cumbersome process. And the computerization of the textual data is easier and simpler and faster. And it started earlier in the 1980s, and this thing started later. So I am more worried about the slow pace of digitization of cadastral maps, because unless and until the longitude, latitude and the spatial thing is tagged and integrated with the textual thing, the whole thing would again be philosophical. It would be of no practical use. That is what I was discussing with Mr. Klaus also once, and that is perhaps what he has also in very modest and very polite language pointed out to me also in his presentation, and he's right. That thing has to come across. But once we can achieve these two things, that the digitization of cadastral maps starts fast, we integrate the textual and the spatial, and on the other hand, we connected with our computerization of registration is going on very well, and the national generic software is a very good thing, and it is the states are moving very fast towards this common generic software for the simple reason that we are, through the National Informatics Center, NIC, we are providing the technical assistance, and the states also, they have a limited number of sub-registrar offices. They say, okay, fine, it's an easier task. It's more easy than digitization of cadastral maps. So the states are doing it faster. So once we have computerization of registrar's offices is also easier. There are limited number of 6,000 plus odd offices. So registration of computerization, a common generic software, and connection with the revenue offices. Digitization of cadastral maps is the big eyesore, and then integration. These are the four essentials I was trying to highlight. That becomes our land information management system, read with the national generic software for registration.
It seemed that I thought I would be voting, so I pressed yes, but it's better to turn the microphone on. So, Mr. Secretary, my name is Mika Törhönen, and I work at the World Bank's Global Land and Geospatial Unit, which is the operational part of the World Bank. So we do quite a lot of land records modernization projects, actually. And I would think one particular set of experience and depository of knowledge in our projects would be quite interesting source of comparison for what's India land records modernization program is doing. In particular, I'm talking about the Eastern European, Central Asian experience in the aftermath of Soviet Union. In 1992, huge change went across 27 countries. And basically, there were no land registries at that time. There were lots of land use records. There were lots of building records for various controlling and fee collection purposes, but there were no land registries of legal rights. And the cadastre was done for other purposes than securing legal rights. And and all was paper-based. There was lots of governance problems, lots of inefficiency, much worse situation than in any of the states in India now, I would say. And if we look at what is the situation today, about 20-some years ago, later, maybe 25 years ago, 25 years from the start, if we look at the registering property part of the Doing Business Index, in the top 20, there are 9 countries from this region. And in some ways, it compares to India, in some ways doesn't, of course, but the business is the same. It is about integrating land records, interlinking them. It's about updating the legal situation on the ground to match with the outdated records, and all coming together. And in the end of the process, there is a stage where you have all electronic environment, all interlinked, and paper becomes obsolete in the business. And there are several countries that have reached that state. So I just offer that as a possible comparison in an event in India, for example, at some stage, I think it would be relevant. We have, in the unit where I work with, we have had over 40 projects in this region, in this team. And there's also, I would like to inform you of two initiatives that concern India. We have a project on land records and geospatial records and disaster risk management, resilience. And one of the case studies that's just starting is on India. So we're trying to see what is the impact of land and geospatial infrastructure to the resilience and disaster risk preparedness. And it's one of the case studies is India. We have 8 other case studies, and we are doing an international conference later this year, and also a flagship publication on the topic, just to mention that. The other thing is that we are also in contact with an Indian state. They would be interested in some kind of review on land records modernization program. And if you had a few minutes after the meeting, it would be excellent if we could shortly discuss that. That's all from my side. Thank you.
I'm grateful for your interjection. Very logical, very appropriate. One more thing I would like to add to what you have observed. You see, when we talk of India, it is not a country. The sheer population. You see, one and the second point which Mr. Klaus also pointed out, that over the years, because of so many pressures on law and order and on development and on infrastructure, our revenue administration has not been given the emphasis that was required, which we are now trying to shift back. But keep in mind also the population things. A small district like Kanpur city, about 2 decades back, I used to be the district minister there. At that time, its population was 4 million. And so many countries, and 4 million, and out of which, and the floating population coming during the day and going away, that was also substantial. So there are so many countries which would only be having that much of population. So for this type of a place where everything is congested with population, and records are the essence of the whole thing in the rural areas, this sort of a process will definitely be slow, but then we have to make it qualitative, accurate, and sure.
Yeah. Thank you, Secretary Dinesh, and also Klaus, for placing this huge enterprise that India is undertaking in perspective. I've had the privilege of looking at this from very different angles. I'm now Director of Research at University of East London, but I work for the Solicitor General of India at Delhi, and then as Public Prosecutor for the State of Tamil Nadu, handling also land disputes, and then for the Planning Commission in Tamil Nadu and work for the government. But working with, as a founder member of the Global Land Tool Network, we've been concentrating also on the sort of social dimension of land in terms of women's access to land, youth and minorities, and etc. And I'm coming to say that as much as the excellent work that you're doing, very obviously part of your mandate is also to work with other departments at various levels and etc. How much headway have you made in showing this innovative work in getting other ministries involved as well as the states? How do you see your success both in terms of partnerships as well as communications in these changes that you've brought about?
See, the unasked question was that what have we done for becoming gender neutral in land evolution? So I'll answer that. As I also mentioned that our succession under the revenue laws is different from that under the civil law. Civil law, they are gender neutral now, after the amendment in the Hindu Succession Act in the first decade of, I think, the beginning of the first decade of this century. But as far as the revenue laws are concerned, they have traditionally been inclined towards the male lineage. So, and I will just explain this thing. Just give me this thing. In Uttar Pradesh, I'll just give one example. It was that it went to the sun. If the sun was not there, it went to the son's son. If the son's son was not there, it went to the brother. The brother's was not there, it went to the brother's son. Then it went to the male lineage. And then it went, no, it's very logical, I'll come to it. Why it happened. We are talking of villages. Then this was legislated also. Then it went to the unmarried daughter till as long as she did not get married off. And then it went to the married daughters. So about, I think in the late 90s, I was secretary in charge of the revenue department in Uttar Pradesh. At that time, we legislated. So the maximum which we could achieve at that time, which still is the law now, is that we said, okay, along with the sons, give one share equal to the sons. If there are 3 sons, they are giving one share each to the unmarried daughter and to the widow also. Otherwise, the mother was lower down in hierarchy. So that thing became the law. So the logic for that when we were discussing it was that at least the sons will take care of the mother in case she has got one share. Otherwise, she will not be taken care of. And they will at least take care of the unmarried daughter if she has one share. But then the flip side, which also happened over the next 2 decades, was that they started getting their sisters married off to unbecoming grooms. They started ill-treating their mothers and pestering her to write her share to one son or the other. So these things have also to be taken. We cannot legislate for an ideal by being blind to the socio-economic milieu for which we are legislating. But that is the job of the lawmakers. It is not my job. I have to just advise them. But I personally feel that the lawmakers, in their wisdom, have not erred. In case they have not made them gender neutral till now, because they come from the same socio-economic milieu and they represent the same socio-economic milieu and they legislate and make the laws for the same socio-economic milieu. So land is slightly different from movable assets like gold and money and other things. And the daughter is generally married away from the village. She can't carry the land with her. She can carry the money, she can carry the movable assets.
Yes, 2 more questions here and here. And
thank you. My name is Ram Janakiram. I work on digital solutions projects in the World Bank here for rural development. Hello? Yeah, okay. Yeah, that was an excellent overview and excellent presentation. The rapid progress being made in digitization and computerization of land records is just marvelous. It's a leading example for the rest of the world. Now, you mentioned that land market is very dynamic, and which is absolutely correct. But in order to make this land market more transparent, requires the land valuation also to be made public. That is, the prices of land, buying, selling, and all that kind of stuff. And we have a long way to go on that one. In your opinion, sir, what more needs to be done to make this happen so that it can be truly transparent and also avoid various forms of deal making which goes on, which does not get reported? And this requires, I think, new forms of public-private civil society partnerships. I think that's an area perhaps we need to give some attention to. Thank you.
Very well said, sir, that valuation of land should be also transparent and it should be available in the public domain. But what is the value of land? The proof of the pudding is in the eating, that when you sell it, the amount you get is the value of land. That is the market value, the sale price. If you acquire land, that is one valuation. Another valuation is that if you are having a transaction on land, what is the amount on which you pay the stamp duty, which Mr. Klaus was saying is now outdated in the 21st century. So out of all these, and there are so many other ways of valuating land also. Out of all these things, the most basic and standardized thing is the circle rate, which is the value of land fixed by the collector, which will be taken as the official value in case there is any transaction on land. So that is what I have said in our presentation, that at least we can put one, again I'm emphasizing that word, one standardized valuation of land on the land record database. That gives a rough idea that, okay, the circle rate is not the market value, but it is one standardized value. And if you compare it with another standardized value using the same parameters, you will come to know that, okay, that land has got more circle rate, this land has got less circle rate, that land is more expensive. It will be more expensive when I sell it in the market also. So that, and what we are doing is a very simple thing, that this is the rate and this was fixed in the year such and such. Only two things. Sometimes the collectors don't fix it for years together. So that circle rate has no relevance unless and until we know when it was fixed. So the year of fixing it and the circle rate, one standardized valuation we are giving on this thing. Otherwise, auction rates, market values, if we see the registration documents, people evade stamp duty and they understate the thing, and it is not the actual market value. In land acquisition, we pay some compensation, but the final compensation is decided after litigation. It generally goes up also, and that takes about 10 years, 15 years, 20 years, depending upon to the level to which it goes. So to exactly say, as an objective bird's eye view, that what is the value of this land, the best possible thing which we can do is to put the circle rate there and leave it to the guesstimate of the person concerned, what he wants to make to do with that. At least let that be there.
One last quick question.
So I have I have 3 questions, but you can answer 1, 2, or all. First one is, in your record of rights, is there any private citizen who owns the minerals, like subsurface rights? Second one is, you mentioned disputes, that there are lots of land disputes. What percentage are related to boundary disputes? And then thirdly is, what are the issues surrounding the slowness in the digitization of cadastral maps? What are the issues? Are there resources, or how can you speed it up?
The first question, sir, answer is no. He does not have rights over minerals. They belong to the state. The second is this, which was the second one?
What percentage of the disputes are boundary related?
I'm not having the percentages of this thing with me now. Most of the disputes are not, boundary disputes are also there, but most of the disputes are on succession and land grabbing. Land grabbing because the land records are not available and not updated. So land, we call it land mafia. Mafia is a very famous word now. So it's originated from here. So the land mafia which go after land which is in dispute, etc., that is one form of dispute. And the second form of dispute is dispute in succession over wills. Boundary disputes are relatively less. If a person's boundary is here or there, they fight with each other and then they sort it out. But generally they don't end up in murders and in breaking arms and legs and all those things. Arms and legs and murders are generally for land grabbing and for succession. And the third one, yes, this cadastral map, one, we started late, and then it is a technical subject. Textual, you just need a data entry operator, he will feed it. That fellow, and they make mistakes also, then you keep on rectifying them because they sometimes. This thing is a technical thing. The technical know-how is limited. Now it's generally gearing up, and we started late. And it's a thankless job. They have so many other things to do. They don't want to do it. It's as simple as that. They have to be pushed. Nobody wants to do it.
Is that if you allocate resources, you can outsource it and people can do it like very fast.
Outsourcing of a record without making sure that the original is not tampered with. Perhaps the situation is not ripe in our nation as of now. It is better to get it done from a person who can be dismissed from service and held accountable. for the time being, then perhaps we can think of others. Because that fellow, what will we do with him? This fellow, at least we can take action.
Okay, very good. With that, on that note, let's draw it to a close. I think thank you all for what I think was a very fascinating and far-ranging discussion of a very complex and interesting project and topic. And I think yes, and I think I'm sure we could continue so quite a bit. So with that, let's all give Secretary Singh a hand of applause. Thank you.